Trump's election win, along with his cabinet picks, who's who of unqualified loyalists and a handful of conspiracists, only underscores that the real winner of this year's election was the algorithm. It's only intensified the debate over whether the First Amendment's protections are adequate in a world where the proverbial town square is monopolized by wealthy elites. Our current understanding of the First Amendment's free speech clause comes from early 20th century Supreme Court decisions, including one from Justice Oliver Wendell Holmes, whose famous concept of the marketplace of ideas, the theory that a free and open exchange of ideas will allow the best ones to prevail simply on their merits. But that theory has been increasingly tested in the digital era, where information is filtered through algorithms deliberately engineered to prioritize profit or perhaps nefarious messages over truth. And arguably, the First Amendment falls short because it was never intended to protect those who can't afford the megaphone. Justice Holmes' famous assertion that there is no such thing as a false idea, which went on to influence later cases and supports a maximalist approach to free speech, meaning the more speech, the better, presumes a level playing field, one in which all ideas compete equally. In reality, the struggle for free speech in America has fundamentally been a fight for access. George Washington law professor Marianne Franks writes, quote, "When the drafters of the Constitution set out the rights of we the people, they meant people like themselves, white, male, Christian, and wealthy," end quote. Franks argues that throughout our history, the First Amendment has, in practice, subordinated the perspectives of women and minorities to the dominant voices of white, wealthy men. Speech that challenges social hierarchies, what she calls radically democratic speech of equality and inclusion, or in the title of her book, Fearless Speech, has been despised and violently suppressed throughout American history. In the 1830s, for example, abolitionist literature, one of the first radical speech movements in America, was violently suppressed by Southern legislatures. The 1873 Comstock Act banned content related to women's sexuality and reproductive health under the guise of protecting public morality. That law, by the way, is still on the books and could be used against women again very quickly. Black Lives Matter protesters were tear-gassed and jailed. According to Franks, quote, "The First Amendment's mythical status as the uncompromising guardian of free expression for all is the product of historical revisionism, selective attention, and limited imagination. What has been protected in the United States above all is not fearless speech in the service of equality, but rather reckless speech in the service of racial and gender hierarchy." While great strides have been made over the centuries to transform Americans' false claim of democracy into a true one, the original ruling class has done everything it can to resist this. The values of white male supremacy and the speech that reinforces them have always received heightened protections in our society, end quote. Franks argues that historically, Americans who have advocated for justice and challenged the status quo have more often than not been denied the same protections of the First Amendment. White wealthy men, for example, continue to assert their dominance over these same groups. Today's Republican Party is actively working, as I mentioned, to revive the Comstock Act in order to police women's sexuality, bodily autonomy, abortion, the pill. While Republican officials throughout the country are banning books and actively rewriting history to suppress inconvenient truths, recent Supreme Court decisions, including Buckley v. Valeo and Citizens United v. FEC, have only exacerbated this imbalance, equating spending by billionaires literally with free speech, allowing the wealthy elite to monopolize the so-called marketplace of ideas while leaving ordinary Americans powerless to compete. And nowhere is this more evident than in the digital sphere, where information is filtered and controlled by those who own the platforms. Elon Musk's X, for example, is widely credited with helping Donald Trump win the presidency. Once touted as a digital town square, X, formerly known as Twitter, has morphed into a toxic space that amplifies hate speech, conspiracy theories, and far-right propaganda, making the very premise of the First Amendment, a free and open exchange of ideas, virtually obsolete. When wealth and power collude to determine who gets to speak, when powerful tech companies control public discourse, shredding any sense of shared reality, this vast imbalance undermines the foundational promise of free speech. And that's probably why a growing number of legal scholars say that it's high time that we revisit our approach to the First Amendment if we truly desire a more democratic society. According to Marianne Franks, quote, "The First Amendment, in theory, is neutral with regard to the matter of speech it protects. In practice, it has been deployed most visibly and effectively in the service of powerful anti-democratic interests, misogyny, racism, religious fundamentalism, and corporate self-interest, end quote. The First Amendment should protect everyone, she argues, not just those with the means to amplify their voice. Otherwise, this marketplace of ideas will continue to ring hollow, serving as a playground for the rich and the powerful, leaving we, the people, to suffer the consequences. Franks argues that we need to reimagine our relationship to the First Amendment, one in which reckless speech does not define the boundaries of our law. Quote, throughout history and to the present day, extraordinary and inspiring speakers have risked their safety, their reputations, and in some cases their lives to call out injustice and hold the powerful accountable. Most of them were never plaintiffs in famous First Amendment cases, championed by the American Civil Liberties Union or lionized in Hollywood films. But their stories and their speech can enlarge our understanding and appreciation of the gift of speech and its role in the unfinished project of equality, end quote. Professor Marianne Franks is standing by. She's the author of a brand new book, Fearless Speech, Breaking Free from the First Amendment. She joins me after a quick break. Before the break, I told you about a growing movement calling for a re-examination of the First Amendment's free speech protections. Joining me to discuss this argument is Marianne Franks. She's a professor of intellectual property, technology, and civil rights law at George Washington Law School, president of the Cyber Civil Rights Initiative, and a newly released book called Fearless Speech, Breaking Free from the First Amendment. Professor Franks, great to see you again. Thank you for being on the show with us this morning.
Thank you for having me.
It's a complicated argument you make, but you're arguing that the First Amendment is both somewhat misunderstood by people and misused historically by people. It's not the great equalizer we have often thought that it should be.
That's right. I think we tell ourselves this kind of myth that the First Amendment has always kind of stood up for the little person, for the person who's been dissenting, for the vulnerable. But when you actually look at history, it turns out that the First Amendment has actually played a very small role in defending the rights of those who have spoken out the most radically against oppression and inequality. And then in many cases, the First Amendment has actually been used as a kind of weapon against those who have been trying to speak out in that way. And I think we, as Americans, have a really hard time coming to terms with that because we really want to believe that the First Amendment is this kind of shining beacon and has always been throughout history.
And you write very early in your book of examples in which free speech has protected a lot of people who, look, we may not like their view, but it has protected some pretty outrageous things, but has not come to the same defense of those who would fight abolition, who would fight for the right of women to vote, who would fight for the right of black people to enjoy equal civil rights in this country, who would fight against for the Black Lives Matter movement. You pointed out that for whatever reason, the law has not protected people who want social change and want to change our hierarchies the same way it has protected those who would preserve our hierarchies.
Right, and that goes against exactly the story that we often tell ourselves, right? We say the First Amendment's there for those who are doing the radical thing, who are arguing for justice. And we like to believe that. We like to say that it's there for the disempowered and for the vulnerable. But when you look at what actually gets characterized that way, when we talk about who is the unlikable speech or the controversial speech, it turns out it's actually not those people. It's actually people like neo-Nazis, or it's the KKK, or it's pornographers, or it's whoever that actually, for whatever else they might be, they're not disempowered. They're not people who are speaking something completely radical or different from the vision of America that's been around. So we've got this very weird understanding of what actually constitutes the unpopular or the controversial or the threatened.
Talk to me about what a reimagined concept around free speech looks like, what the framework looks like. Are you actually talking about something that changes the Constitution, or just the way we interpret how speech should be protected in this country?
I think it's important for us to think at any point where we're talking about reimagining or reinterpreting, we're really just talking about doing what we've always done with the First Amendment, because the First Amendment is not self-executing. It's not self-explanatory. It took over 100 years for the United States to decide, for the Supreme Court to decide that this is not just a protection that exists against the federal government, but also exists against state government and other forms of state-sponsored suppression. So we've always had to engage in this process of interpretation and application. So anyone today who is trying to say, let's think carefully about this and let's talk about whether we're doing it in a way that is just or fair, this is just continuing the project of trying to interpret a document that is not exactly, it hasn't been handed down to us from the heavens, but is, created by men and applied and practiced by people over history, so that we just need to do a better job of it sometimes. And that's really all that I'm calling for here. It's not an amendment to the Constitution, because that's a practical, almost a near impossibility, but rather, if we are doing what we do as lawyers, as scholars, as members of the public, the First Amendment belongs to us, and it belongs to the way that we as the people want to interpret it. Let's do a better job.
This is just the beginning of a very important conversation. I really recommend people read this book, because it really does help us understand this. You and I are going to have a longer conversation at the Strand on Monday on Broadway in New York. So if anybody's in New York and wants to come to this thing, look it up, and I'll post it on my social media. But thank you for this great conversation. Marianne Franks is a professor at George Washington Law School, president, legislative and tech policy director at the Cyber Civil Rights Initiative, and author of multiple books, including her latest, Fearless Speech: Breaking Free from the First Amendment.